Alternative obligations. Alternative obligations are present when there are two or more prestations, but the debtor is obliged to completely perform only one. For example, the debtor agreed to deliver either a pig or a goat. Delivery of the goat will extinguish the obligation, and the debtor need not deliver a pig. How about generic obligation? Note the difference between an alternative obligation and a generic obligation, the latter being limited to a particular class. Thus, if the obligation is to deliver a goat without specifying the specific goat, the debtor can choose any goat. In a sense, there is an alternative, but the same is limited to the same class. The debtor cannot, therefore, deliver a dog. Additionally, it should also be pointed out that alternative obligations are not conditional in nature. The act of choosing does not suspend the effectivity of the obligation. The obligation is effective, but the exact prestation is not yet fixed. Who will make the choice? General rule is that the debtor is the one who has the right to choose. Exception: the debtor does not have the choice if 1. There is an agreement that the choice is granted to the creditor, or 2. There is an agreement that a third person will make the choice. When is the choice effective? Article 1201 provides that the choice is effective the moment it is communicated to the other party. Article 1205 provides that when the choice has been expressly given to the creditor, the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. Example: if the debtor is obliged to deliver either a car or a house, and he informed the creditor on June 1st, 2013, that he opts to deliver the car, the choice is effective on June 1st, 2013. The obligation becomes simple, and the election that was made is irrevocable. Is it not necessary for the other party to consent? If the debtor communicated his choice to the creditor, the choice is effective even if the creditor disagrees with the choice. Exceptions: the creditor may question the choice in the following cases. 1. The prestation that was chosen is impossible. Or 2. The prestation that was chosen is unlawful. Or 3. If it could not have been intended that the same is one of the alternatives, it was not one of the intended options. How about third party's choice? If the choice belongs to the third persons, the choice is effective the moment the same is communicated to all parties. In other words, notice should be given to the debtor and the creditor. How is the choice made? A. The choice can be expressly made. For example, the debtor may send a letter to the creditor expressing his choice. B. Implied, as in the case where only one alternative remains. For example, the debtor can deliver any of the 3 houses that were specified. However, 2 of the 3 houses were destroyed by a calamity. And C. Constructive, if the debtor performed one, like delivery of the object, and the same was voluntarily accepted. What happens when the debtors cannot or do not make a choice? There are the rules that should be applied when the debtor who has the right to choose cannot make a choice. A. Debtor cannot make a choice due to creditor's fault. Article 1203. The debtor may rescind plus damages. B. Debtor did not make a choice because of his debtor's own fault or his refusal to make a choice. He may be compelled to make a choice in a court case. Specific performance is not immediately available. Nevertheless, to avoid multiplicity of suits, the creditor can file a case to compel the debtor to choose, and after making such choice, to compel him to perform the prestation that he has chosen. What is the effect of loss or impossibility if the choice is with the debtor? Article 1204. 1. Only one option remains. If all the other alternatives are lost or would otherwise become impossible, the debtor may comply by delivering or complying with the remaining prestation. Example: Mr. A agreed to deliver Mr. B any of his 3 dogs that 2 died in the meantime, Mr. A can deliver the remaining dog. What happens if there are 2 or more options remain? If 2 or more options remain, while the other alternatives or alternatives are is lost, or compliance becomes impossible, the debtor should choose any of the remaining prestation. Example, Mr. A has 3 cats, and he is obliged to deliver any of the 3 cats. One of the cats died. Mr. A should choose between the 2 remaining cats. Note, if in the previous example, A and B, the loss of the dog or the cat, as the case may be, was due to the fault of the debtor has no liability for damages, and all that is required is for him to deliver the remaining dog or any of the remaining cats. What happens if all alternatives are lost? The debtor is liable for damages if 1. The loss of the last object or prestation is due to his fault. Even if he caused the loss of the other alternatives, he will not be liable if he was not the cause of the loss of the last remaining alternative. Thus, he will not be liable if the cause of the loss of the last alternative object is solely a fortuitous event. What happens if it was lost after election? This shall be governed by the rules on simple obligation to give. What is the effect of loss if creditor is given the choice? It should be noted that the obligation shall cease to be alternative from the moment the selection by the creditor is communicated to the debtor, and in case of loss before the choice is made, the rules to be followed as prescribed in Articles 1205 of the New Civil Code are as follows. 1. If one of the things is lost through a fortuitous event, the debtor shall perform the obligation by delivering that which the creditor should choose from among the remainder, or that which remains if only one subsists. 2. If the loss of one of the things occurs through the fault of the debtor, the creditor may claim any of those subsisting, or the price of that which, through the fault of the debtor, has disappeared, with a right to damages. 3. If all the things are lost through the fault of the debtor, the choice by the creditor shall fall upon the price of any one of the things lost, also with indemnity for damages. Liability for damages. Note that even if there are remaining alternatives, 1 or more remains, the debtor will be liable for damages if the other alternatives are lost due to his debtor fault. Thus, if the creditor can make the debtor deliver either a horse or a motorcycle, and the motorcycle was totally destroyed due to the negligence of the debtor, the creditor may claim the horse plus damages. Facultative obligations. Article 1206. Facultative obligations refer to a situation where only one prestation was agreed upon and due, but the debtor may render another in substitution. Example, the obligation of Mr. A is to deliver a car to Mr. B, with an agreement that Mr. A may substitute the obligation to deliver a car with performance of a service. Distinctions. In alternative obligation, there are 2 or more prestations that are due. Under facultative, there is only one prestation that is due. In alternative, the debtor can choose any of the alternatives. In facultative, the debtor has only one choice but with the right to substitute. In alternative, the debtor, in a certain case, may be liable for damages if the choice is with the creditor and loss of any alternative is due to the debtor's fault. In facultative, loss of the substitute due to the debtor's fault will not make the debtor liable. Note, if the principal is lost or is void, there is no need to give the substitute. In alternative, the choice is generally with the debtor, but it can be given to the creditor and a third person. In facultative, the option to substitute is always with the debtor. What is joint and solidary obligation? Solidary obligation, that is under Article 1207, is one in which each of the debtors is liable for the entire obligation and each of the creditors is entitled to demand the satisfaction of the whole obligation from one or all of the debtors. When the contract states that all the signatories are solidarily liable, any one, some, or all of them may be proceeded against for the entire obligation. The choice is left to the solidary creditor to determine against whom he will enforce collection. The obligation is solidary if it is stipulated that 1. The liability is joint and several. 2. Obligation in solidum. 3. Persons are liable, together or separately. And 4. Persons are liable individually or collectively. Requisites of solidary obligation: plurality of subjects, 2 or more creditors and or 2 or more debtors. Unity of prestation: the shares of each creditor or debtor is not determined. While joint obligation is one in which each debtor is liable only for a proportionate part of the debt, and the creditor is entitled to demand only a proportionate part of the credit from each debtor. Each obligor answers only part of the whole liability, and to each obligee belongs only a part of the correlative rights. None of the obligors can be compelled to satisfy in full the obligation. The obligation is joint if it is stipulated that 1. The liability is pro rata, or 2. The liability is a proportionable joint obligation. Mancomunidad simple is the term used in the Spanish Civil Code. Requisites of joint obligations: 1. Plurality of subjects, 2 or more creditors and or 2 or more debtors. 2. Each creditor or debtor has a determined share in the demandability or fulfillment of the obligation. What is the presumption under Article 2008? The presumption is that the obligation is joint. Exceptions: the obligation is solidary only if 1. There is an agreement that the obligation is solidary, conventional. 2. When the nature of the obligation contemplates solidary obligation, natural. And 3. When the law provides for solidary liability, legal. Solidary obligation cannot be lightly inferred. So what are kinds of solidary obligations? 1. According to source: conventional, 2. Natural, or 3. Legal. Examples: under conventional, the agreement states that Mr. A and Mr. B are jointly and severally liable to pay $1,000. Under natural, Mr. A and Mr. B own a house and they mortgage the same to secure their obligation to Mr. X. The mortgage obligation is by nature solidary. And legal: 1. Liability of joint tortfeasor in quasi-delict is solidary. 2. The liability of the makers in a promissory note that states I promise to pay even if there are 2 or more makers is solidary. 3. The recruiter and agent in the Philippines of a foreign employer of an overseas worker is solidarily liable with the employer for violations of contractual stipulations. And 4th, when there are 2 or more bailees to whom a thing is loaned in the same contract, they are liable solidarily. How about according to the parties? 1. Passive. This pertains to the liability of the debtors. Each debtor may be compelled to pay all. Or 2. Active. This pertains to the right of the creditor. Each creditor have the right to compel payment of the entire obligation. And as to applicability of the terms and conditions, we have uniform. All terms and conditions apply to all. The creditors or debtors are bound in the same manner and by the same periods and conditions. 2. Non-uniform. The period, terms, and conditions may vary depending on the debtor involved. One condition may be applicable to one, but not to the other. The creditors and debtors are not bound in the same manner and by the same periods and conditions. What is the nature and effect of joint obligation? A. Unless the nature of the obligation or the stipulation indicates the contrary, the shares of each debtor or creditor shall be considered equal. B. Default or delay of one debtor will not affect the other. And C. Other debtors may not be compelled to perform all the obligations. What is meant by indivisible obligation? An obligation that is indivisible is not necessarily solidary, and an obligation that is solidary is not necessarily indivisible. In other words, the prestation may be indivisible, but the obligation may be joint. For example, an obligation to deliver a specified cat is indivisible because the parties cannot divide or apportion the obligation. However, the obligation may still be joint. This is true because the indivisibility of the obligation is the result of the indivisibility of the object or the prestation, while an obligation's joint or solidary nature involves the tie that binds the parties. Distinction. Under solidary, there should be two or more creditors and two or more debtors. Under indivisible, there can be only one creditor and only one debtor. In solidary, the prestation remains the same even in case of non-performance. Under indivisible, the obligation is converted into one for damages in case of non-performance. Under solidary, each debtor is liable for the breach of the other debtors. Under indivisible, the debtor is not liable for the breach of the others. And in solidary, performance may be done by one, while indivisible, collective performance is usually required. What is the effect of joint indivisible obligation? 1. Act of one joint creditor does not prejudice all, and the collective acts of all is required. Example: the filing of a court case by one joint creditor stops the running of the prescription period as to his share in the credit only. As to other joint creditors who did not file, the prescriptive period continues to run. For instance, the creditors have 10 years to file a case, and only one filed a case within such period. Hence, the action has prescribed as to the others. 2. The creditor must demand performance only against all joint debtors. Demand to one is not effective for all joint debtors. 3. Insolvency of one debtor will not affect the others, for non-compliance by one debtor will not convert the obligation into one for damages or monetary obligation. Problems. X, Y, and C, who are joint debtors, owe $18,000 to A, B, and C, who are solidary creditors. How much can B collect from X? B can collect $6,000 from X since A, B, and C are solidary creditors. Any one of them can collect the entire amount of $18,000. However, since the debtors are joint debtors, they can only collect the share of each debtor. They cannot recover the entire obligation of $18,000 from one debtor. In the given problem, the share of each joint debtor is presumably $6,000, but each of them may be made liable by any of the solidary creditor. Thus, B can recover $6,000 from X, $6,000 from Y, and $6,000 from Z. Suppose in problem number 3, X, Y, and Z are solidary debtors and A, B, and C are solidary creditors. How much can be recovered from X? B can collect $18,000 from X. The solidary creditors can claim the entire amount from any of the solidary debtors. X and Y are solidary debtors and B, C, and A, who are joint creditors, in the total amount of $30,000. How much can B collect from X? B can collect $10,000 from X. Since B is a joint creditor, he can only recover his share in the total of $30,000, which is presumed to be $10,000. However, he can recover the entire $10,000 from one of the solidary debtors, X or Y. Each solidary debtor, X or Y, can be made to pay the entire amount pertaining to one joint creditor. In problem number 5, suppose X and Y are joint debtors and A, B, and C are joint creditors. How much can be recovered from X? B can recover only $5,000 from X every joint creditor has a presumed share of 10,000 and the credit of 30,000. However, B as joint creditor cannot collect the entire amount of 10,000 from either X or Y. B can collect his total share of 10,000 by collecting 5,000 from X and 5,000 from Y. Another example, A, B, and C borrowed 120,000 from X. This debt, as evidenced by a promissory note, wherein the three bound themselves to pay the debt jointly and severally. However, according to the note, A can be compelled to pay only on June 1st, 2010. B can be compelled to pay only on June 1st, 2011, while C can be compelled to pay only on June 1st, 2012. On June 1, 2010, X made a demand upon A to pay the entire indebtedness, but the latter paid only 40,000 subsequently. Because of A's refusal to pay the balance, X brought an action against him for collection of the amount. Will such an action prosper? As in 1988 bar. Reasons. The action will not prosper. Article 1211 of the New Civil Code provides that the solidary character is not destroyed by the fact that the debtors are bound by different periods for payment. Thus, the solidary nature of the obligation is not affected by the fact that the obligors in this case are liable on different dates. In the present case, the share of each solidary debtor in the total obligation of 120,000 is presumably 40,000. It is submitted that since each solidary debtor can be compelled to pay on different dates, the right of the creditor to collect is limited to the solidary debtor or debtors whose obligation or obligations has or have matured, and the recovery is limited to the amount owed by the debtor or debtors whose obligation or obligations has or have already matured. Hence, only A is liable on June 1st, 2011, and the liability is limited to 40,000. X will have to wait for June 1, 2012, when B's obligation shall be matured, and for June 1, 2013, when C's obligation shall have also matured. If X was to recover 40,000 from A on or after June 1st, 2011, he can collect 40,000 from either A or B on June 1st, 2012. If X was able to collect the 40,000 on June 1st, 2012, in addition to the amount he previously collected from A, he can again collect another 40,000 from either A or B or C on June 1st, 2013. In Chowsty versus Yulo, 34 Phil 978. Suppose in the same problem the obligation of the parties is joint. Will the action prosper? The action will still not prosper, even if the obligation is joint. The difference, however, is that on June 1st, 2012, only B is liable, not A or B. And in June 1st, 2013, only C may be made liable, and not A, B, or C. What are the rules on active solidarity? Articles 1212 to 1216. Active solidarity is solidarity among creditors. There are two aspects of the rules. These are 1. Rules that govern the relationship between the solidary creditors and the debtors, and 2. Rules that govern the relationship of the creditors among themselves. What are the relationship between solidary creditors and debtors? One solidary creditor may ask for full payment or full compliance with the obligation. Example, Mr. X, Mr. Y, and Mr. Z are solidary creditors, and Mr. A borrowed from them 30,000. On its due date, any of the three, Mr. X, Mr. Y, or Mr. Z, can demand payment of the entire obligation of 30,000 from Mr. A. Under Article 1214, the moment a demand is made by one solidary creditor, payment must be paid to him. Example, Mr. X, Mr. Y, and Mr. Z are solidary creditors, and Mr. A borrowed from them 30,000. On its due date, any solidary creditor can demand payment of the entire amount, 30,000. However, the moment one of them makes a demand, payment must be made to him. Thus, if Mr. X made a demand, Mr. A must pay Mr. X. Under Article 1215, any one of the solidary creditors may extinguish the obligation. Extinguishment may be total or partial, and it may be through novation, compensation, remission, or any other means recognized under the law. Example, Mr. X, Mr. Y, and Mr. Z are solidary creditors, and Mr. A borrowed from them $30,000. Mr. A can remit or condone the entire obligation of Mr. A, which condonation binds Mr. Y and Mr. Z. How about among creditors? And before I continue, I'd like to ask a favor. If you like this audio, kindly like and share, and do subscribe. It makes me feel good about myself. Now, if you don't like this audio, do not just hit that dislike image, but do leave a comment so I'll improve. It makes me feel good about you and forever be grateful. Thanks. If the solidary creditor was able to recover from the debtor, he must thereafter give the share of the other creditors. Example, Mr. X, Mr. Y, and Mr. Z are solidary creditors, and Mr. A borrowed from them $30,000. On its due date, any of the three, Mr. X, Mr. Y, and Mr. Z, can demand payment of the entire amount of $30,000. If Mr. X made the demand and Mr. A paid the entire amount of $30,000 to him, Mr. X must give the respective shares in the credit of Y and Z to them. Under Article 1212, solidary creditors may do whatever may be useful to others. Example, the filing by one solidary creditor of a case against the debtors stops the running of the prescriptive period and makes legal interest due and payable. Likewise, under Article 1212 and the second paragraph of Article 1215, solidary creditors may not do anything that is prejudicial to the other creditors. Example, Mr. X, Mr. Y, and Mr. Z are solidary creditors, and Mr. A borrowed from them $30,000. Mr. X can remit or condone the entire obligation of Mr. A. However, Mr. X may be made liable to the other solidary creditors who did not consent to the condonation of their shares in the credit. Thus, Mr. X is liable to pay Mr. Y $10,000 and Mr. Z $10,000. Note, the solidary creditor may in effect prejudice the rights of the creditors as against the debtor or debtors under Article 1215 by extinguishing the obligations of solidary debtors. Under Article 1213, a solidary creditor must get the consent of the other creditors before assigning or transferring his right or share in the credit. However, there is an opinion to the effect that the provision applies only if assignment is made to third persons. Prior consent is not necessary if the transfer or assignment is made to one of the other solidary creditors. Novation may result in prejudice or benefit to the solidary creditors. In novation, the obligation is modified by changing the object or principal condition, by substituting the person of the debtor, or by subrogating a third person in the right of the creditor. If the novation is prejudicial to the creditors, the creditor who caused the novation shall be liable to the other solidary creditors. If the novation is beneficial to the creditors, the creditor who caused the novation must share the benefits to other creditors. Note, the extension of time given in favor of one solidary debtor will not release the other debtors. There is no extinctive novation. The exemption is in the case of a surety. Compensation takes place when two persons are creditors and debtors of each other, and the respective obligations are extinguished up to the extent that they coincide. Example, A, B, and C are solidary creditors who lent $3,000 to Mr. X. Mr. A borrowed $3,000 from Mr. X. Both obligations are extinguished if they are both due and payable. However, Mr. B and Mr. C have the right to claim reimbursement from Mr. A. What is the rule when there is passive solidarity? Solidarity among debtors. Relationship between the creditor and solidary debtors. One solidary debtor may be obliged or sued to perform the entire obligation. The other solidary debtors are not indispensable parties in a case against one of the solidary debtors. Example, Mr. A, Mr. B, and Mr. C are solidary debtors who are obligated to deliver to Mr. X 30 sacks of rice. Mr. A may be compelled by Mr. X to deliver 30 sacks of rice. Even if the demand is made on one solidary debtor, demand can be made on the others so long as there is no full compliance. Example, in the previous example, if Mr. A was only able to deliver 10 sacks of rice, Mr. X can demand the delivery of the remaining 20 sacks of rice from either B or C. Under Article 12(22), a solidary debtor may raise defenses against the creditor. These defenses may either be 1. Defenses that are derived from the nature of the obligation, example, prescription or failure to file the case within the period prescribed by law. Thus, an action based on a written contract must be filed within 10 years. 2. Defenses that pertain to one debtor only, however, with respect to those which personally belong to the others, a solidary debtor may avail himself thereof only as regards that part of the debt for which the solidary with personal defense are responsible. Example, A, B, and C are solidary debtors in the total amount of $30,000. A is a minor. In this case, B and C can raise as a defense the minority of A. However, the defense is only with respect to the share of A, which is presumed to be $10,000. B and C can still be made solidary liable up to $20,000. 3. Defenses that pertain only to the share of one debtor. Example, the obligation of one debtor is subject to a separate condition or period. 4. Defenses that pertain to the other debtors. Example, Mr. A, Mr. B, and Mr. C are solidary debtors who are obligated to deliver 30 sacks of rice. Mr. B is a minor. If Mr. X demanded delivery from Mr. A may raise the defense of minority of Mr. B to defeat the claim, but only as to proportionate share of Mr. B, which is presumed to be 10 sacks of rice. Payment by one solidary debtor extinguishes the obligation. Example, if Mr. A, Mr. B, and Mr. C are solidary debtors who are obligated to pay Mr. X $30,000, payment by Mr. A of the entire amount will extinguish the obligation of all of them. Mr. X can no longer claim from the other debtors. What happens if the thing which is the object of the obligation disappears or the prestation becomes impossible? If it is due to the fault of one or all of the solidary debtors, each solidary co-debtor shall be liable for the value of the obligation and damages. Example, Mr. A, Mr. B, and Mr. C are jointly and severally obligated to deliver Mr. X carabaos that are now in the farm of Mr. A. All the carabaos died due to the fault of Mr. A. In this case, Mr. B and Mr. C are also liable to Mr. X. If 2 or more solidary debtors offer to pay, the creditor may choose which offer to accept. How about the relationship among solidary debtors? If one of the solidary debtors paid the creditor, he can claim reimbursement from the other debtors. However, there is no right of reimbursement if he paid after the obligation has prescribed. Examples: 1. Under a written agreement, Mr. A, Mr. B, and Mr. C are solidary debtors who are obligated to pay Mr. X $15,000. If Mr. A paid Mr. X $15,000, he can claim reimbursement of $5,000 from Mr. B and $5,000 from Mr. C. 2. In the previous problem, Mr. A cannot claim reimbursement if he paid 12 years after the obligation became due because the claim already prescribed. A solidary debtor who has a right of reimbursement is also entitled to interest if he paid on due date. He is not entitled to interest if he paid before the obligation is due. If one of the solidary debtors is insolvent, the share of the insolvent debtor shall be borne by the other debtors. Example, Mr. A, Mr. B, and Mr. C are solidary debtors who are obligated to pay Mr. X $15,000. If Mr. A paid Mr. X $15,000, he can claim reimbursement of $5,000 from Mr. B and $5,000 from Mr. C. However, if Mr. B is insolvent, Mr. C will shoulder half of B's share of $2,500. Hence, Mr. A can claim reimbursement from Mr. C in the amount of $7,500. A solidary debtor is not entitled to reimbursement if he paid the obligation after the obligation has prescribed or after it has become illegal. Example, if the obligation will prescribe in 10 years, but one debtor paid after 10 years, the paying debtor will not be entitled to reimbursement from the other debtors. A solidary debtor who paid the remaining debt may claim reimbursement even against a debtor whose share was remitted by the creditor. While a creditor may release one solidary debtor only, the debtor who is released remains to be a solidary debtor. Examples: 1. Mr. A, Mr. B, and Mr. C are solidary debtors who are obligated to pay $15,000 to Mr. X. Mr. X released or remitted the share of Mr. C on June 1, 2005. However, the remission was made after payment was made by Mr. A on May 10, 2005. In this case, Mr. A is still entitled to reimbursement for the whole amount from Mr. C. 2. In the previous example, if the remission was before payment, Mr. A may be compelled to pay $10,000. 3. Mr. A, Mr. B, and Mr. C are solidary debtors who are obligated to pay $15,000 to Mr. X. Mr. X released or remitted the share of Mr. C. If Mr. B becomes insolvent, Mr. C is still liable to pay the share of A and B. A solidary debtor who was able to obtain release or remission of the entire obligation is not entitled to reimbursement. Example: Mr. A, Mr. B, and Mr. C are solidary debtors who are obligated to pay $15,000 to Mr. X. Mr. X released or remitted the entire obligation at the instance of Mr. C. Mr. C cannot claim reimbursement from Mr. A and Mr. B. What are divisible and indivisible obligations? Indivisible obligations are those that are not susceptible of being executed or performed in parts by reason of their nature or as provided by law or by agreement of the parties. The fact that the obligation is indivisible does not mean that the obligation is solidary. The peculiarity, however, is that it cannot be performed by only one in part. Thus, the effect of non-compliance is to convert the obligation into one for damages and to make the debtors liable thereafter for their proportionate share. Thus, the joint indivisible obligation to deliver a horse is converted into one for damages in case of breach. Kinds of indivisible obligations. Natural indivisibility. This is present if the nature of the obligation is that it cannot be performed in parts. For instance, the thing or service to be performed is physically incapable of being performed in parts. Example: A, B, and C are obligated to deliver a specific dog. Second, legal indivisibility. The law itself declares the obligation as indivisible. In this type, the object, thing, or service may be divisible or indivisible. Third, conventional indivisibility. The parties agreed that the obligation is indivisible. In this type, the object, thing, or service may be divisible or indivisible. What is the rule when divisible or indivisible? In obligations to give, the obligation to deliver a specific or definite thing is always indivisible. Example: obligation to deliver a specific oil painting. 2. In obligations to perform service, the obligation is divisible if it will be executed within a certain number of days of work. Example: A, B, and C will clean the house of Mr. X for 3 days. 3. The obligation is divisible if the work is to be accomplished by metric units. Example: Mr. A, B, and C will transfer 1,000 kilos of rice of Pedro from one warehouse to another. 4th, it is divisible in any other case which by their nature are susceptible of partial performance. 5. Even if the obligation is divisible by nature, The same may be rendered indivisible by law or by agreement of the parties. Finally, if the obligation is indivisible by nature, it cannot be made divisible by law or agreement of the parties. What are obligations with a penal clause? A penal clause is in the nature of an accessory obligation which makes one party liable or makes him perform another prestation if the principal obligation is not fulfilled. The penalty clause takes the place of indemnity for damages and the payment of interest in case of non-compliance with the obligation unless there is stipulation to the contrary. And purposes: 1. Inducement. A penal clause helps ensure the performance of an obligation. 2. Punitive. Punishment for non-compliance. 3. Deterrence and retribution. 4. To fix in advance the damage that may be awarded in order to do away with proof thereof later. What are the kinds of penal clauses? 1. Subsidiary or complementary. The penal clause is subsidiary if only the penalty will be enforced in case of breach. A penal clause is complementary if both the principal obligation and the penalty can be enforced. Another is conventional or legal. There is conventional penal clause if the same was agreed upon or stipulated by the parties. Legal penal clause exists because it is expressly stated in the law. Example: the parties may agree in the contract to construct a building and that the contractor will be liable to pay a penalty of 1,000 for every day of delay. Nature of penal clauses. 1. Penalty is not an alternative. Article 1227. The enforcement of the penalty is made only if there was non-compliance with the principal obligation. Consequently, it is not an alternative obligation which can be chosen by the debtor. Example: 1. The parties may agree in the contract to construct a building that the contractor will be liable to pay a penalty of 1,000 for every day of delay. The contractor cannot choose to pay 1,000 pesos per day instead of constructing the building on due date. The exception is if there was an agreement that he can make such replacement. 2. A contract of lease may provide for a forfeiture clause, a provision that allows the lessor to forfeit in its favor advance rentals and deposits if the lessee deserts or vacates the premises. 2. Generally not complementary. Article 1227. The rule is that the creditor can either demand fulfillment of the obligation or enforce the penalty. The creditor cannot demand both unless 1. There is an agreement that he can enforce the penalty and at the same time demand performance of the obligation, or 2. The performance of the obligation becomes impossible. 3. Proof of actual damages not necessary. Article 1228. The rule that proof of actual damages is not necessary is rooted in the purpose of a penal clause. The penalty is meant to deter violation and to punish violation. Thus, if the penalty clause provides for the payment of 10,000, the party who is claiming such need to prove that he was damaged up to 10,000. 4th, effect of nullity of principal obligation or accessory obligation. Article 1230. There is a well-known principle in law that accessory follows the principal. This principle is affirmed in Article 1230 in the sense that the nullity of the principal obligation carries with it the nullity of the penal clause. However, the nullity of the accessory does not carry with it the nullity of the principal. The accessory follows the principal and not the other way around. Example: the penalty was declared grossly unconscionable and therefore void. The principal obligation to pay is still valid. Problem illustration: the Betty's Furniture Company undertook to deliver to Mr. Bagong Casal's specified pieces of living room, dining room, and bedroom furniture, all made of nara for a price stated in the contract. The agreement had a penal clause that any violation of the contract would entitle the aggrieved party to damages in the amount of 100,000. The furniture delivered by Betty's was made not of nara, but of inferior wood. In a suit to recover damages, Bagong Casal was able to prove that the actual damages he sustained amounted to 200,000. He demanded that amount plus the 100,000 penalty, or a total of 300,000. Betty's, however, countered that if it were liable for damages at all, the maximum award should not exceed 100,000 as stated in the penal clause of the contract. Whose claim would you sustain? Why? The claim of Betty's should be sustained under Article 1228. No proof of damage is necessary in order for a penal clause to be enforced. Damages may be awarded in the concept of penalty in the absence of proof, provided that the penal clause was freely agreed upon. When can penalty be reduced? The penalty may be reduced by the judge in 3 cases. 1. When there was partial compliance. Example, the obligation of Mr. A is to deliver 100 sacks of rice with a penalty of 1,000 if not paid within the due date. If Mr. A was able to deliver 90 sacks of rice, the court may choose to reduce the penalty. 2. When there was compliance but it was irregularly done. Example, in the preceding example, if there was delivery of 90 sacks of rice of the quality or type agreed upon. Example, C for rice plus 10 sacks of rice which are not of the variety agreed upon. 3. When the penalty is iniquitous or unconscionable. Example, the penalty is 100,000 per day even if the principal obligation is only 10,000. Extinguishment of obligations. Concept of extinguishment of obligation. An obligation is extinguished if it ceases to exist. Extinguishment of an obligation under the new civil code may include termination because of full compliance with the obligation, extinction before full compliance, or even the end of the obligation, which may have been partially complied with. Grounds for extinguishment. The grounds for extinguishment of obligations under Article 1231 and other provisions of the new civil code are as follows. 1. By payment or performance. 2. By the loss of the thing. And 3. By the condonation or remission of the debt. 4. By the confusion or merger of the rights of creditor and debtor. 5. By compensation. 6. By novation. 7. By annulment. 8. By rescission. 9. By fulfillment of a resolutory condition. 10. By prescription. 11. By death whenever personal obligations are involved. 12. By expiration of a resolutory period. 13. By compromise. 14. By impossibility of performance. And 15. By fortuitous event.